Welcome to Thinking Deeper by 6-7.
Today we are strapping in for a deep dive into a document that sounds deceptively dry, but let me tell you, it is packed with some absolutely explosive legal and, more importantly, theological detail. We're looking at Albert G. Mackey's seminal 19th century examination of Masonic law.
That's right. For this deep dive, we are unraveling a meticulously structured, almost constitutional world that governed the world's largest fraternity. And we are talking about a system where Grand Masters wielded, well, almost absolute unappealable authority.
It's like a kind of kingly prerogative right inside the lodge.
Exactly. And all of that power was checked only by unwritten ancient tradition.
And this whole internal jurisprudence, it's just a study in profound paradox. We're going to analyze these astonishingly strict admission rules, things like requiring absolute physical perfection down to the smallest limb.
And then we're going to confront this fascinating and honestly very tricky boundary of religious tolerance.
Masonry famously embraced this idea of universality, only requiring a belief in God. But then it used that same foundational belief to establish a legalistic hurdle.
A hurdle that legally defined an atheist as fundamentally unfit to testify in a Masonic court.
Yes, incapable of speaking the truth under a sacred sanction. It's an incredible collision of belief and evidence.
So this is a deep dive into how codified law ensured obedience, structured a transnational organization, and maintained these archaic principles that really defined its very identity. We're tracing the line between ancient usage and statute law to understand the true bedrock of this centuries-old society.
And really, what happens when the rules of belief clash head-on with the rules of evidence? Okay, so let's unpack this. This is a monumental legal effort. Albert G. Mackey publishes the Principles of Masonic Law in 1856, and his mission, well, it was critical.
He saw a problem.
A huge one. He recognized that Masonry, by the mid-19th century, was just suffering from legal chaos.
Yeah, he wasn't just trying to create another big, dense book. He actually called them unwieldy, these huge digests of decrees. He specifically pointed out that Grand Lodges and Grand Masters, especially the new ones, were often issuing edicts based on, what was it?
Inexperience, of prejudice, or of erroneous views. That's the direct quote.
And the worst part, these decrees were constantly contradicting each other across different states, different jurisdictions.
Absolutely. Mackey was essentially fighting a kind of institutional entropy. And his core revolutionary statement, the thing that gives his work so much intellectual gravity, is this really simple reality check.
Which is?
The Grand Masters and Grand Lodges, while they deserve the utmost respect and obedience, are not infallible.
Ah, that's a big statement to make.
Huge! It means their decrees should not be blindly accepted as immutable law if they clash with established principles.
So his ambition was to create something more elementary, more methodical. He wanted to present these abstract governing principles that would allow a member to understand the spirit of the law, not just memorize a bunch of conflicting rules.
Exactly. He wanted to give the fraternity a general map.
Right, like Blackstone did for English common law. I think he even mentions Blackstone.
He does, and that analogy is perfect. The whole goal was that if you, the learner, understood the fundamental principles, you could trace the bearings of the law themselves and form a correct opinion on a specific case.
Even if a Grand Master had just ruled the other way.
Especially then, it shifts the emphasis from this kind of arbitrary authority to a reasoned legal application.
Okay, so to build this map, Mackey identifies two primary sources of authority. And this mirrors secular law, right? The lex non scripta and the lex scripta.
Exactly. The unwritten and the written law.
Let's start with the unwritten, the lex non scripta. What is that exactly?
The lex non scripta is the true antiquity of the craft. It's derived from ancient traditions, usages, customs. These are practices that have existed, from the remotest antiquity, and they are universally admitted and practiced across the entire order.
So it's the common law of Masonry.
That's the perfect way to put it. It's binding, even without a formal written statute, just sustained by collective memory and, continual practice.
But that must present challenges, right? If it's unwritten, how do you define its precise boundaries? How do you stop people from just making things up?
That is the perpetual challenge. But its strength, its legal test, lies in its consensual nature. It is only considered part of the lex non scripta if it is universally admitted.
Ah, so if a specific usage is common in, say, New York, but not in England,
then it defaults to being just a local regulation, not universal law. that universality is the hallmark of true ancient usage.
Okay, so then in contrast, you have the lex scripta, the written law. This must be much clearer, being derived from actual documents.
Much clearer. And the foundation here included things like the ancient Masonic charges, a body of rules that they believed originated way back in the reign of James II.
Hey, what else?
Then you have, significantly, the regulations adopted at the General Assembly in 1663. But perhaps the most enduring part of the written law, and one that's often overlooked, are the installation interrogatories.
The questions that are put to the master of a lodge when he's installed, why are those legally significant?
Because these questions, which cover all the fundamental duties and commitments of the office, were universally adopted by all Grand Lodges without any alteration.
I see.
So Mackey argued that since they are uniformly accepted, they form a binding, universally acknowledged part of the lex scripta.
So you have these two pillars, the foundational customs and the official statutes. But any legislative body, like a Grand Lodge, could potentially run wild and try to change the fraternity's core. Where is the inviolable check on all this power?
That check is the concept of the old landmarks. This is the highest legal authority in Masonry. It's the single inviolable limitation on all subsequent Masonic authority.
Including the Grand Lodge and the Grand Master.
Absolutely.
And the source material is pretty emphatic on this point, isn't it? It explicitly states that anybody making new regulations must always ensure that the old landmarks be carefully preserved.
That phrase is a commandment. It is not a suggestion. And it's coupled with that declaration, the one that's often recited during the installation ceremony.
Right. It is not in the power of any man or body of men to make any alteration or innovation in the body of Masonry.
And think about what that means. It is an astonishingly conservative legal declaration. It essentially enshrines perpetuity.
It forbids revolutionary change. It maintains the institution's historical identity, even if it feels archaic or, inconvenient in a more modern era.
Exactly. The very identity of the craft is bound up in these landmarks. If a newly enacted regulation by a Grand Lodge conflicts with an ancient usage that constitutes a landmark,
then that new regulation is just null and void.
it is. The landmark always wins, even if it's difficult to define precisely what constitutes a landmark versus just some old local custom. And preserving those limits is the core duty of every single presiding officer.
Okay, so let's shift from that abstract legal framework to the concrete structure of governance. We need to understand how the supreme governing body evolved, because the modern Grand Lodge structure, it's actually relatively new. It only dates back to 1717.
That's a crucial distinction. For nearly 800 years, from 926 A.D., at least according to tradition, the Supreme Judicatory was the General Assembly of Masons.
And that was a completely different beast than today's Grand Lodge.
Oh, completely.
How so?
It was far more democratic, or maybe anarchic, depending on how you look at it. The assembly was composed of as many of the fraternity at large as could physically attend.
So it wasn't restricted to representatives?
Not at all. Any competent brother could open and hold a lodge at his own discretion. They didn't need a formal warrant of constitution. They would just meet, elect a general head, and legislate.
So the power rested with the collective body of Masons, not with a select delegation of masters and wardens. What on earth necessitated that pivot in 1717?
Well, the shift was driven by a need for consistency, for order, for accountability. In 1717, the Gish Crafts was reorganized, and the key change was adopting a strictly representative model.
Which meant?
It meant the privilege of assembling as Masons became restricted only to authorized, warranted lodges. By accepting a warrant from this new collective body, the brethren at large implicitly vested their privileges in the masters and wardens of those specific lodges.
This raises a pretty fundamental legal question, especially for expansion. How do you start a new Grand Lodge in a new jurisdiction, say, in the American West?
Yeah.
Can a bunch of Masons just meet up and declare themselves a Grand Lodge?
Absolutely not. And that's a key point. The formation of a Grand Lodge is entirely dependent on the preexistence of legitimate subordinate lodges.
So no mass meetings.
Exactly. A mass meeting of Masons cannot assemble and organize a Grand Lodge, because the GL is, by its very definition, a convention of delegates representing already warranted bodies.
Okay, so what's the necessary minimum? How many lodges do you need?
This was a point of some debate, but precedent settled the matter pretty quickly. The Mother Grand Lodge of England, the very first one, was formed in 1717 by only 4 existing lodges.
Just 4.
And the historical minimum was really cemented when the Grand Lodge of Texas was organized in 1837. The representatives came from only 3 lodges, and it was immediately recognized as legal by all the sister jurisdictions.
So 3. 3 warranted subordinate lodges are sufficient to birth a sovereign Grand Lodge. That seems surprisingly thin for establishing paramount authority over a huge territory.
It is thin, but the legal mechanism that solidifies the new authority is mandatory. Once that Grand Lodge is formed, those 3 or 4 subordinate lodges, they must surrender their original warrants.
The ones they got from England or France or wherever.
Right. They surrender those, and then they receive new ones from the body they just created. And that formal act instantly transfers all Masonic authority for that territory to the new Grand Lodge.
So once that Grand Lodge is formed, who actually comprises the membership? Who holds the legislative and judicial power?
By inherent ancient right, the membership consists of the masters and wardens of all the regular subordinate lodges, plus the elected grand officers.
Okay.
But a point of clarification often missed, which Mackey really stressed, is who is not a member by inherent right.
And that is...
The past master.
Wait a minute. If you've served as the master of a lodge, you don't automatically get a seat for life in the Grand Lodge. I thought that was a long-standing tradition.
It has become a tradition in many places, but only by local courtesy or a specific regulation. It's not by ancient law. And the source material notes that this restriction arose largely out of, well, expediency.
Financial necessity.
Exactly. Imagine if every past master claimed a seat, the Grand Lodge would become massive and unwieldy.
So logistical constraints are dictating the form of governance.
Precisely. The text notes that paying mileage and expenses to 3 representatives from a single lodge was already a heavy burden on Grand Lodge revenue.
Wow. So if every past master was suddenly added to that, the financial weight would become completely unsustainable.
Right. It's a subtle but profound insight. The operational costs of a fraternity can actually override an ancient custom and shape its constitutional framework.
Speaking of ancient customs being overridden, you mentioned this delightful, almost comical regulation about the craft's right to inspect new constitutional alterations.
Yes, the ancient right of the craft to participate was codified in this rule, requiring that any proposed constitutional alteration had to be offered for the perusal of all the brethren.
Even of the youngest entered apprentice.
Before dinner at the annual feast.
Before dinner. That has to be the greatest motivation for speedy legislation known to man.
Indeed, it's a remarkable glimpse into the social dynamics of 17th century Masonic life. But unfortunately, the source acknowledges that this regulation just became obsolete.
Once the Grand Lodge transitioned into a strictly representative body, it just became impractical for thousands of Masons to gather for a pre-dinner legal review.
That is impossible.
So once this representative body is legally formed, what are its 3 fundamental defined powers?
They're separated into 3 distinct classes, and they all stem from their inherent right to legislate as long as they respect the landmarks. First, you have legislative power.
Okay.
This is the power to enact local laws and regulations. And it's key to note the distinction here. Subordinate lodges can only propose bylaws. The Grand Lodge must enact or confirm them. The subordinate lodge has no final say on the law.
Makes sense. Second, the judicial power.
This is their role as the Supreme Masonic Tribunal. They have the inherent power to investigate, regulate, and decide all matters that arise in their jurisdiction. And crucially, 2 powers belong almost exclusively to the Grand Lodge.
And those are
The power to erase subordinate lodges from existence, and the power of expulsion.
the ultimate penalty.
The ultimate penalty, severing a brother's ties to the entire craft worldwide. A subordinate lodge can recommend expulsion, but the final judgment and the confirmation, that rests solely with the Grand Lodge.
That makes sense. An action that affects a Mason globally should require the highest authority.
Exactly. And then finally, the executive power, their paramount authority. This includes granting the permanent warrants of constitution to lodges that the Grand Master had initially granted a temporary dispensation to. The Grand Lodge is the Lord Paramount in its jurisdiction, restrained only by the old landmarks. It functions as the ultimate sovereign within its defined territory.
So if the Grand Lodge is the supreme legal parliament, then the Grand Master is clearly the constitutional monarch. He holds a level of personal authority that seems, well, it seems almost foreign to a modern elective office.
That monarchic analogy is highly accurate. The office itself is arguably older than the modern Grand Lodge. It's existed from the very origin of the institution. It was always necessary to have a presiding head, a unifying figure.
Someone to represent the craft externally and govern it internally.
Precisely.
So let's get to the most controversial aspect of the office, the power of unappealable decision. It is settled by ancient usage that there is no appeal from the Grand Master's decision while he is presiding over the Grand Lodge. That sounds like absolute legal supremacy.
It is absolute in that moment. The Grand Master is entitled to 2 votes, and his pronouncements from the chair are final. Mackey and all the subsequent jurisprudence confirms this.
They cite cases, right?
Yeah, like Brother Williard in New York in 1849, where an attempt to appeal the GM's ruling was just thrown out. The Grand Lodge of Maryland famously sustained this, declaring an appeal from the GM to be an anomaly at war with every principle of Freemasonry.
But doesn't that inherently contradict the whole notion of a representative body? If the leader's decision cannot be appealed, what mechanism is left for the representatives to check any abuse of power?
This is the central paradox. Theoretically, there is a check. It was adopted way back in 1721.
And it says what?
If the Grand Master should have used his great power, he shall be treated in a way and manner to be agreed upon in a new regulation.
But you have to look closer at the process required to actually enact that new regulation.
Ah, yes. It required the consent and approval of the majority of all brethren present, including the youngest entered apprentice, and it had to be proposed months in advance.
That procedure renders the punishment almost impracticable, to use the source's own language. In the structure that evolved, especially by the 19th century, with grand lodges covering enormous geographic areas and membership bases.
Achieving that kind of widespread consent for a new regulation to remove a sitting Grand Master was virtually impossible. Right, so the legal system placed a theoretical check on him, but it intentionally made the mechanism for enforcement so bureaucratic and cumbersome that he was effectively insulated from punishment.
So his primary deterrent becomes internal, his own conscience, and external.
The loss of his brethren's regard and esteem. A moral check, not a legal one.
And his authority extends far beyond just the gavel. He holds the dispensing power. How is that defined?
It's defined as the authority to grant an exemption from the observance of some law or the performance of some duty. And this power, critically, is limited only by the ancient landmarks.
Okay, give me some robust examples. How does this dispensing power operate in the daily life of a lodge?
All right, consider lodge admissions. There is a general regulation that a lodge shouldn't initiate more than 5 new brothers at one time. If there's an urgent necessity, say a group of exemplary men are about to deploy overseas for military service, the Grand Master can dispense with that number restriction for that one night.
Or take elections. Usually a master has to have served as a warden.
Right. But if all the former masters and wardens refuse to serve, which creates a leadership vacuum, the GM can issue a dispensation, allowing the lodge to elect a master directly from the floor, bypassing that customary requirement.
He can also override regulations concerning a Mason's membership geography.
Yes. There was a regulation concerning the bills of mortality, basically a 3-mile radius, that generally forbade a brother from belonging to 2 lodges within that small area.
But the Grand Master could just waive that.
If the circumstances warranted it, the Grand Master of a jurisdiction like South Carolina could exercise his prerogative and dispense with that rule, allowing dual membership inside the prohibited zone. This just shows a massive latitude for him to adjust statutes for local expediency, provided he doesn't touch the landmarks.
This brings us to his most extraordinary and debated prerogative, the one that has caused divisions throughout Masonic history, the power of making Masons at sight.
This is deeply controversial because it appears to undermine the entire orderly process of the subordinate lodge. To make a Mason at sight means the Grand Master convenes an occasional lodge.
Temporary.
Exactly. Solely for the purpose of initiating, passing, and raising a candidate. And once the degrees are conferred, that occasional lodge instantly ceases to exist.
And the historical use of this power primarily involved high-ranking nobility, right? Almost as a matter of statecraft.
Frequently, yes. The sources cite several instances involving royalty. In 1731, Grandmaster Lord Lovell formed an occasional lodge at Houghton Hall expressly to make the Duke of Lorraine a Mason.
Who later became the Holy Roman Emperor.
The very same. And later, the Duke of Gloucester, the Duke of Cumberland, they were similarly elevated by the GM in these temporary settings. The fact that the most powerful men in the realm were initiated this way gave the prerogative immense prestige and, in the eyes of many, real legal weight.
But those who opposed the practice often claimed these were just special meetings of the Grand Lodge, not truly independent temporary lodges. How does Mackey's legal defense counter that?
The defense centers on 2 things: history and a legal principle called argument a fortiori.
Okay, let's start with the history.
Historically, the records show these occasional lodges were often held at entirely different locations than the Grand Lodge's regular meeting place. The ceremony for the Duke of Lorraine was held in Norfolk, nowhere near London. That proves they were separate temporary entities.
And the legal argument, the argument a fortiori, that literally means from the stronger reason. How does that principle justify this massive unilateral power?
This is the clinching legal justification. The logic goes like this. The Grand Master possesses the unquestioned right to delegate his authority to 7 Master Masons by granting them a temporary dispensation to form a new lodge.
Which allows them to make Masons outside of his presence.
Exactly. So if he can delegate this power to others, it stands to reason, by the stronger reason, that he must retain the right to convene those same 7 brethren and cause a Mason to be made in his presence.
He can't legally delegate a power that he doesn't personally possess.
Precisely. The occasional lodge is just a temporary lodge, legally operating under the Grand Master's dispensing power, which he immediately revokes once the work is done. It's a valid exercise of his defined prerogative.
But there have to be limits.
Oh, absolutely. Mandatory limits. He can't just confer the degrees by communication, meaning he can't just skip the ritual and tell the candidate the secrets. That's a process unknown to the York Rite.
So he has to do the full ceremony.
He must adhere to all established ceremonies and be assisted by the necessary number of brethren. And, most importantly, he cannot use this power to override a subordinate lodge by making a Mason whom that regular lodge had already rejected by ballot. His power is massive, but it is not infinite. So we shift now from the architecture of power to the governance of the individual, specifically how the craft regulates morality and belief. And the entire integrity of the institution, Mackey argued, rests on the character of its members.
Which is why you have that foundational moral mandate. A Mason is obliged to obey the moral law, and that's explicitly referring to the 10 Commandments.
Right. This mandate requires excluding immoral or scandalous men. But the most interesting exclusion is the religious one. It seems to walk this very fine tightrope between tolerance and legal constraint.
Yeah, because historically, Masons were initially charged to be of the religion of their country, which would make any kind of universality impossible.
That's right. The standard evolved pretty quickly because Masonry aspired to be a universal brotherhood, welcoming men from all nations. The final unifying standard became, well, it is now thought more expedient only to oblige them to that religion in which all men agree, leaving their particular opinions to themselves.
And that is the great statement of theological tolerance. It creates a space where men of many different faiths can meet.
It does.
And the common denominator that all men agree upon is the belief in the existence of one God. That's the minimum religious qualification. But where this deep dive gets truly fascinating is when this theological minimum crosses over into the realm of jurisprudence.
This is the critical juncture. The belief in God is not merely a statement of faith for membership. It becomes a competency requirement in a judicial setting.
What do you mean by that?
In Masonic trials, persons who are entirely devoid of any such religious principle or belief as would bind their consciences to speak the truth are incompetent as witnesses.
So the religious constraint is actually a rule of evidence, not a rule of doctrine. The moment you declare that you don't believe in God, you legally lose the indispensable test of truth that the craft relies on to validate any testimony.
Precisely. The power of the obligation, the sanction of the oath, is rooted in the expectation of divine judgment for perjury. Without that fundamental belief, the oath is viewed by Masonic jurisprudence as completely meaningless.
It reduces the witness to an unreliable source.
An unreliable and therefore incompetent source, which is why the testimony of an atheist must be rejected in a Masonic trial. The atheist, as the text says, cannot be subject to that sanction which is deemed an indispensable test of truth.
That is just stunning. It means a Mason could theoretically hold wildly heretical views that might have gotten him persecuted centuries ago, and still be a fully competent witness in a Masonic court as long as he affirms a belief in God.
Yes.
But an atheist, regardless of how morally upright or secularly truthful they might be, is legally disqualified from contributing to justice within the craft.
It's a purely legalistic exclusion. Mackey even juxtaposes this with general secular legal rulings of the time. He notes that even an infidel who believes in a God may testify, even if he doesn't believe in a future state of reward or punishment.
So Masonry follows that secular ruling on the bare minimum belief in God, but enforces it with absolute strictness.
It does. The necessity of this core belief is what maintains the legal integrity of the oath, which underpinned the entire ability of the fraternity to enforce its own moral law.
That distinction belief in God as a requirement for legal standing rather than religious adherence, that's the most surprising nugget of this whole deep dive. It ensures universality up to a point, but draws a non-negotiable line right where judicial necessity begins.
It creates a defined limit on universality. You can be of any religion, but you cannot be of no religion, because the latter legally incapacitates you in their system of justice.
So moving on from these internal faith matters, how does Masonic law handle politics and external affairs, especially politically charged conduct?
Well, Masonry has always fiercely fenced off certain areas from its internal jurisdiction, just to maintain peace and universality. Religious offenses like heresy are explicitly non-cognizable by a lodge.
And importantly, political offenses.
Yes, even extreme ones like rebellion against the state, which is the example the source uses, are also non-cognizable.
Wait, hold on. A Mason who commits treason or rebellion against the prevailing civil power cannot be expelled from the lodge for that act.
Not for the political act alone. The ancient charges insist a Mason be a peaceable subject to the civil powers, and the loyal brotherhood must disown his rebellion, but, and this is the key part, they cannot expel him from the lodge unless he commits a separate Masonic crime like theft or gross immorality during the rebellion.
That is a remarkable prioritization of the internal bond of the fraternity. It suggests that the Masonic jurisdiction is sovereign and separate.
It is. It prioritizes its own peace and the loyalty to the individual brother above the demands of the state, even in the face of potentially treasonous activity. This is crucial for understanding how the fraternity maintained its existence across all these different political regimes over the centuries.
It reinforces the doctrine of non-interference if Masonry were to take sides in political disputes.
It would instantly fracture its universality. By making political rebellion a non-cognizable offense, it effectively sacrifices civic judgment for fraternal continuity.
The journey to becoming a Mason is notoriously rigorous, and the physical requirements. They seem particularly archaic and unyielding. We have to discuss the ancient law of physical perfection.
This is one of the most visible and debated landmarks. The role requires that the candidate must be a man of 21 years or older, upright in body with all senses, not deformed or dismembered, but with hale and entire limbs as a man ought to be.
And the emphasis there is on perfect. If the law requires perfection, it allows for 0 degrees of imperfection, which means a minor physical deficiency, say a missing finger, technically disqualifies a man who might otherwise be exceptional.
Exactly. And the source material really delves into why this strictness exists. It's not just about the practical ability to perform the ceremonies and give the signs, though that is a requirement. It is profoundly symbolic.
Okay, explain the symbolic element that justifies such a strict exclusion.
The physical perfection is required because the Mason is meant to represent the perfect stone or the perfect ashlar in the spiritual temple. A defect, however small, destroys this symbolism, as the spiritual temple must be built of materials perfectly prepared.
So it's about adhering to the symbolism, the reason and spirit of the ancient legislators.
Exactly, and that's what maintained the law against all the modern critique.
And this wasn't just some historical curiosity, it was a heated legal debate in the 19th century. This idea of a latitudinarian construction, it argued for more flexibility.
Yes. The argument was, if a candidate, despite a slight name, could still physically perform the ceremonies and fulfill all his duties, why on earth should he be excluded?
But the strict constructionists held the line.
They did. Supported by powerful Grand Lodges like New York, Maryland, and South Carolina, they stood fast. They insisted on literal physical perfection, prioritizing the preservation of the symbolic integrity of the landmarks over expediency or modern sentimentality.
Their fear was that if they allowed one small physical defect, where would the line be drawn?
The entire meaning of the perfect stone would be lost.
So beyond the body, what about the mind and social standing?
Intellectually, the candidate must not be a fool, an idiot, nor a madman. The mind has to be sound enough to comprehend the esoteric teachings.
And literacy.
Well, there wasn't an ancient law explicitly forbidding those who couldn't read or write because, literacy wasn't universal when the craft was formalized. But the consensus had evolved by Mackey's time.
How so?
Since Masonry presents itself as a scientific institution focused on the liberal arts, a person who couldn't read and write was generally considered not legally qualified for full participation in the intellectual project of the craft.
And then there's the deeply archaic social qualification, the free-born rule.
This rule is one of the most difficult elements of the ancient law to grapple with. The candidate must be freeborn. This excludes not only the slave, but also someone who was born into servitude and later gained freedom.
And the justification for that is what?
The justification cited in tradition is historical and symbolic. The example of Ishmael, the son of the bondwoman Hagar, who could not be heir with Isaac. This establishes an inherited status that determines eligibility, regardless of a man's current freedom or virtue.
So once a candidate, having cleared all these incredibly strict requirements, finally approaches the lodge, they still face the bulwark of Masonry,
The unanimous ballot.
which is sacrosanct.
Absolutely. The sixth general regulation requires the unanimous consent of all the members of that lodge then present. This right to cast a negative vote is an inherent privilege of every single member, and it's designed entirely to secure the independence and harmony of the lodge.
And because it's an inherent privilege, the Grand Master cannot interfere. It is not subject to a dispensation.
Correct. And the secrecy of that ballot is inviolable. No Mason can ever be called to account for his vote, even if it's clearly driven by personal prejudice. The philosophy is simple. One negative vote means the potential for disharmony is too great.
The rule is designed to prevent a turbulent member from being imposed on the brethren.
Exactly. It ensures the foundational harmony of the lodge remains undisturbed.
Now, assuming a man passes the ballot and becomes an entered apprentice, progression isn't automatic. He has to prove himself.
Absolutely not. Advancement is strictly stage-gated. The candidate must show suitable proficiency in one degree before he's permitted to advance to the next. And this proficiency must be determined by a formal, tested examination conducted in open lodge.
And the temporal rules are strict to prevent rushing him through.
They are. It's universal law that all 3 degrees cannot be conferred at a single communication. And many jurisdictions, following the English precedent, require no more than 1 degree on the same day, with a minimum interval, often 4 weeks, to ensure there's sufficient time for study and for the proficiency exam to be meaningful.
Okay, finally, what happens if an entered apprentice is rejected by ballot when he applies to advance to the fellow craft degree? Does he face discipline?
The outcome hinges entirely on the reason for the rejection. If he's rejected purely by ballot, with no reason given, no trial is necessary, he simply remains an apprentice in good standing, though he can't advance in that lodge.
But what if the objection to his advancement stems from issues of his moral worth? Say, a subsequent discovery of scandalous behavior.
Then the lodge is bound to take action.
They can't just silently reject him and let him languish as an apprentice.
No. If the objection is based on moral turpitude, the lodge is compelled to give him a full trial. And if he's found guilty, they must expel him from the craft entirely.
So they are forbidden from using the secret ballot as a passive way to sideline a morally unworthy brother.
Exactly. They have to prosecute the offense fully, ensuring the moral integrity of the order is maintained. So once a man is a master mason, he acquires these specific rights and duties, even when he's traveling abroad. And one of the most fundamental is the universal right to visit.
This right is secured by that ancient regulation that commands all Masons to receive and cherish strange fellows. But as we know, in Masonry, every right comes with some substantial checks and limitations.
Indeed it does. The first restriction is that the visitor must be an affiliated member of some lodge. An unaffiliated Mason loses this universal right.
And second,
Before he can even enter the examining room to prove his proficiency, he has to submit to the Tyler's obligation.
let's detail that obligation because it really underscores the intense level of security required before any communication can begin.
The oath is a full legal declaration under the highest sanction. The visitor has to swear, I, A.B., do hereby and hereon solemnly and sincerely swear that I have been regularly initiated, passed, and raised to the sublime degree of a Master Mason in a just and legally constituted lodge of such.
That I do not now stand suspended or expelled and know of no reason why I should not hold Masonic communication with my brethren.
It's a comprehensive oath. It covers his entire history and his present standing. It ensures he isn't under suspension and that his original initiation was legitimate.
And after that oath, he still has to pass a rigorous examination.
Oh yeah, and it must commence at the beginning. The rule regarding scrutiny is absolutely stringent. It is better that 99 true men should be turned away from the door of a lodge than that one cowan and impostor should be admitted.
The preservation of secrecy and integrity outweighs the inconvenience to a genuine brother.
By a huge margin.
Okay, moving to membership logistics. A Master Mason can gain formal affiliation with the lodge where he was raised just by signing the lodge bylaws. There's no second ballot required.
Correct. And for a Master Mason applying for membership at any other lodge, he can do so regardless of location. And critically, if he's rejected for membership for affiliation by one lodge, it does not impair his good standing in the craft in general.
It's purely a rejection for local membership, not a judgment of his character or moral worth.
Exactly.
This brings us to the thorny issue of the unaffiliated Mason the brother, who chooses to resign or demit from his lodge membership. It's voluntary, but it carries enormous consequences.
Mackey argues that the act of demission is a right. A Mason's initiation was voluntary, so his continuance in the order must be equally so. However, the act violates that ancient precept that every brother ought to belong to a lodge.
Maintaining his contribution and participation.
Right.
So what is the heavy price paid for that freedom? What specific rights does the demitted brother forfeit?
By divesting himself of membership, he loses all organizational rights attached to the local lodge. This includes the universal right of visitation, which is severely restricted, often allowing him to visit each local lodge only once.
And more tangible things.
Yes, the right to pecuniary aid, so financial support from the lodge, and the right to a Masonic burial. When he approaches the door asking for assistance, he is legally viewed in the light of a profane.
That's incredibly harsh. He's treated as if he were never a Mason when asking for assistance because he sacrificed his organizational support network.
It is, and yet the principle of once a Mason, always a Mason still holds for the deepest duties. The unaffiliated brother is still bound by his highest obligations, absolute secrecy, and the duty to render immediate aid in the imminent hour of peril.
The grand hailing sign of distress.
Exactly. And the precept for rendering that aid is so absolute that when that desperate plea is made, no inquiry into his status should be made. His mortal need overrides all the rules about good standing or affiliation status.
Let's finalize the legal landscape with the process of discipline. What are the recognized penalties that the craft can use?
The hierarchy of penalties ranges from a reprimand to exclusion, which is a temporary removal from a meeting, to suspension, either definite or indefinite, and then the ultimate, expulsion.
The most common modern issue seems to be suspension for non-payment of dues. How does this disciplinary custom fit into the ancient framework?
Well, suspension or erasure for non-payment of dues is noted by Mackey as a modern custom. It arises from the lodge's financial needs. Dues are a special contract between the member and the local body.
So the question becomes whether suspension for a financial default should affect his standing with the craft in general.
Right. And while it's often disputed, the legal ideal is that suspension for dues should not impair his ability to visit other lodges in different jurisdictions, as long as he hasn't been tried for a separate moral offense.
And what distinguishes a definite suspension from an indefinite one in terms of restoration?
This is a crucial distinction about fairness. If the suspension is definite, say, for 3 months for a specified act of misconduct, restoration is automatic when that term expires.
The lodge can't require a subsequent vote or action?
They cannot. To do so would constitute double punishment for the same crime. Now, if the suspension is indefinite, which is usually for non-payment or for a moral transgression where a term wasn't specified, then a special resolution and vote of the lodge is required to restore him to full standing.
And finally, the ultimate consequence: expulsion.
Expulsion is the complete severance of the bond. The expelled member ceases to be a Mason. His restoration is equivalent to the admission of a profane, a non-Mason. It requires the same unanimous ballot as a brand new candidate for the degrees.
And because expulsion affects the individual's standing with the craft worldwide?
The expelling power has to ultimately reside in the Grand Lodge, or at the very least require its explicit confirmation. What stands out most profoundly, I think, in this deep dive into 19th century Masonic law, especially guided by Mackey's analysis, is this constant tension. It's a tension between the desire for organizational efficiency and the fiercely conservative preservation of these ancient, sometimes contradictory principles.
It's a legalistic world just governed by paradoxes.
Yep.
We saw the Grand Master given near absolute power, an unappealable decision that makes him almost untouchable.
Right.
Yet this power is tethered, checked only by the vague, unwritten, but inviolable limits of the ancient landmarks. It's a power structure that's really built on moral accountability rather than on legal constraints.
And we saw the extreme stringency applied to the human body, this demand for absolute, literal, physical perfection rooted entirely in archaic symbolism, while at the same time enforcing a seemingly broad theological tolerance.
One that requires only a belief in God for admission. But, and this is the key, that tolerance comes with a stunning legalistic constraint. as we discussed in depth, that minimal belief in God is redefined as a competency requirement.
Yes.
If you are an atheist, the craft doesn't necessarily judge you morally, but their internal system of justice deems you legally unfit to participate as a witness. It undermines your entire place in their judicial framework.
That elevation of a theological belief into a rule of evidence is perhaps the most shocking and structurally critical finding here.
This entire framework, it really shows how a vast transnational organization maintained its identity and its structure not through government authority, but through this stack of meticulously codified, sometimes archaic legal codes.
It's a fascinating parallel to how any complex legal system, even one without physical borders, maintains its continuity and demands adherence from its members.
We established that Masonic law is fiercely protective of the individual's internal status, forbidding the expulsion of a member even for profound political offenses like rebellion against the state, provided he commits no other Masonic crime. But here is the provocative thought to carry with you. Given that the ancient charges insist a Mason must be a peaceable subject to the civil powers, and yet the fraternity explicitly refuses to expel him for acts of rebellion, does the law mean the fraternity ultimately prioritizes loyalty to the individual brother and the maintenance of internal harmony above the principles of civil order and peace it claims to uphold?
Something to think about until the next deep dive.